Hey everybody, it's Pastor Andrew Stevens. I'm with the Church Common Good as American Culture TV. Today I want to talk a little bit about First Amendment rights on private property. You might see a lot of First Amendment audits where they're filming from the public property, and anything you can see from public property is well known to be within the rights of the freedom to record or to have freedom of speech. A lot of people don't know that these rights also extend to private property in many ways. We'll start with the beginning of these cases, because it started with a case called Marsh versus Alabama. In Alabama, there was a town that was owned by a private business corporation, kind of like the miners' towns in Colorado way back when. This was in Alabama, though. It's a corporate town. It had all the things of a town, so all the things a municipality would have, such as shopping, a little town square, recreation area. So the people within the town didn't have to leave the town in order to accomplish their day-to-day life. They worked for the company, were housed there, did their retail shopping there, the church was there, everything was on this private property. Well, the Jehovah's Witnesses wanted to do their ministry within this private property, and the company said they couldn't do so. So they filed for an injunction, and they got it. And the reason the Jehovah's Witnesses got this injunction was because this particular town had all the qualities of a municipality. That was a while ago. You had to move forward to other cases. Later on, there was another case called the Food Employees Union Local 590 versus Logan Valley Plaza Incorporated. In this case, is a shopping mall case. Logan Valley Plaza Incorporated is a shopping mall, and there was a picketing going on by the local union of a grocer's a store within the mall that had a grocer's or grocery store, and the employees were picketing for what they considered labor disputes. Now, in this case, because the shopping mall served as a community, the community's business block, like it was the area that most people went and shopped within that community, even though it didn't have all the logistics, all the things of a municipality, it did serve as the area that people would go and do their shopping. So people didn't have to go out of this area, just shopped at this one mall, went back home, and that's because of that situation. The courts also found that the freedom of speech extended to the picketing of this location. Now remember that these picketers were employees of a store within this shopping mall. They lived in this area, and they were disputing labor problems that were related to the shopping mall. So that's a little bit different than Marsh versus Alabama, a little looser, because it didn't have the situation in the municipality, but it was private property, and they were allowed to continue picketing there. Moving forward to Lloyd Corporation versus Tanner. This is an important case. In this case, there was the distribution of handbills or literature. It had nothing to do with the shopping mall's operations. It's completely different issues that were being discussed on these handbills. It had to do with the draft. So the court found that since these handbills had nothing to do with the operations of the shopping mall that Lloyd Corporation owned, and thus they were completely irrelevant, and there was no petitioning against or grieving actions by the shopping mall, the distribution of these handbills was found, the courts found that they didn't have the right to do that. So that one the court shot down. But they shot it down because of the situation. Completely irrelevant. There were other public areas to distribute these handbills, and so they shot down that judgment. Later on, though, and remember this is against the war, so courts are compelled to shoot down protests against wars. But after the war was over, later on, there was another case called Hudgens, Hudgens, versus the National Labor Review Board, or NLRB. The court said in that case that the Lloyd case was the injunction that they had gotten previously. So the handbills were being passed out. They were told no. They filed for an injunction. It was given to them. And then the mall, Lloyd Corporation, took Tanner to court to get the injunction relieved. And when they did that, the courts found that they were in the right, and the people distributing the handbills had to stop. So later on, though, in the Hudgens versus NLRB case, the court found that case, the Lloyd Corporation versus Tanner, the injunction was overruled merely by implication. So they're basically saying that it was a bad decision. The courts were going against the previous courts. And this is how we move into the freedom of speech within private property. Now, the major case happened next. So this case is called Pruneyard versus Robbins. Major case out of California. There's a shopping center called the Pruneyard Shopping Mall. And there are some high school students that were protesting the UN's resolution that was against Zionism, which is the Jewish settlement going on in Israel. So in this time, if you remember the Picot-Sykes Agreement, where Britain gave a piece of Palestine to Israel for settlement after World War II, there was a protest going on against the Zionism, where the UN came against Zionism. So there's protests against the UN's decision, and these high school students were involved in that. What they did was they went to the Pruneyard Shopping Center and they set up a booth in the courtyard of the shopping center. They were distributing handbills and literature and getting petitions signed within the courtyard area. The shopping center said, hey, you guys can't do that. It's against the regulations of the shopping center. You have to leave. The kids decided, sure, we'll leave. And then they filed an injunction, a motion for injunction relief with the courts. The courts at that point in time said many different things. This court was very forthright with the way they saw decisions. Previous decisions were based on the freedom of speech on a federal level. California's constitution is a little more broad than the federal constitution. And what the courts dealt with here was the ability of state sovereignty to have a constitution that was loosely written or had more broad than the federal constitution, as long as it did not conflict with federal constitution. And they found that the states do have a right to interpret these freedom of speech cases using their state constitution in lieu of the federal constitution. In California's case, it reads much like Florida's constitution, which is important because we're currently in Florida doing the Dump Trump campaign at Walmart parking lots, Target parking lots, strip malls, various places of retail establishments where people come and go from their day-to-day activities. We want to create like a town square effect in these places because there's no more town square. There's no more central location to discuss politics. So these cases are very important for us. In this situation, the Pruneyard versus Robbins case, the students were found that they were just totally in the right. The Pruneyard shopping centers could not deny them the right to have their freedom of speech heard within their private property. It was a major dispute between private property rights and freedom of speech rights, and has led to many other decisions. Not many in Florida, however, but there have been a couple. So Florida did have, let's start with the way the Constitution is written, because that's very important with the Pruneyard decision, because it was based on the way California's Constitution was written in comparison to the federal Constitution. And Florida's Constitution is written that every person may speak, write, and publish his sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. The word restrain is in there where the federal Constitution merely says abridge. When you use the word restrain, it implies that you may not impede on my rights or our rights or the people's rights to freedom of speech. Abridge means prevent, but restrain means to impede. So even if something doesn't prevent you from using your First Amendment rights or asserting them, if a law restrains you from that liberty, it may not be passed in Florida. However, as you've seen in previous videos on this channel, that's exactly what's going on with trespassing laws and Walmart parking lots, Target parking lots, complaints from just civilians driving by that saw the Dump Trump bus and didn't like it, called the sheriffs on suspicious vehicles, made complaints to corporations to try to get us kicked off the properties, made complaints to managers. We've had managers of businesses that had at least an area adjoining where we were parking have police kick us off of the entire grounds of a shopping mall area. We've had all kinds of laws being used in the color of law to prevent us from creating a town square effect where we can talk about issues freely in today's society in the area where people use for their shopping and where they spend most of the time that they're not at work or at home or at their church or events. They're either be shopping at like a Walmart or a Target or a Publix, and that's where you can meet people and discuss issues. So that's why we chose these locations. Plus they have a very large lot for our big bus. So this is a very important situation for us. So now you see that Florida's Constitution is very loosely written, more loose than the federal Constitution, almost identical to California's Constitution. There are a few words that are changed in the way they're written, but nothing of any significant value. But the most important part is a restrain word in that. So in Florida, there's been a couple cases dealing with this. The first of which is the NAACP and Webb City Incorporated. Webb City Incorporated was a shopping area, and NAACP was doing picketing, demonstrations, protests for boycotting this business. The business said they sought relief from the courts to get NAACP to leave. It seems the NAACP had stirred up a lot of controversy within the entire community. The community felt uneasy going onto the property to shop at Webb City Incorporated. Not that they had gained support for a boycott, but that their activities at the shopping center had made it unattractive for shoppers to go to. So Webb City's owner went to the courts and said, I can't do business this way. It's affecting my business. I have the rights to do business. You should protect those rights. And the courts did. They found that Webb City Incorporated, their business rights should be free from aggressive and hostile environments that are using freedom of speech as a protection. So they were successful in getting the NAACP to move on, and then their customers came back to the store. There was no real boycott, other than the customers felt intimidated when they went to the store. The only other case that really dealt with this topic is Korn versus State, or State of Florida, I guess would be. Korn, he was a guy, he was the last name Korn. He was shopping at a mall, and he got into an argument with an employee of one of the least businesses within the mall. While he was shopping there. Security came and kicked Korn out, told him that he had to leave the whole mall. If he came back to the mall, he'd be arrested for trespassing. He did return to the mall, and he was arrested for trespassing. He was then convicted of trespassing and appealed that decision to a higher court. And so the higher court ruled that the shopping mall did have a right to have rules and regulations and have a free enjoyment of people to come in and shop and leave. And if someone violated those rules and caused a scene or a disturbance, they could be trespassed from the property and could be subject to arrest if they violated that. Now, to get a little detail in this, he didn't argue these things. He never argued freedom of speech in this case. He argued that the trespassing did not respect equal protections under the law. And so that's what the court ruled on, was about equal protections under the law instead of about a freedom of speech case. Had he asked about freedom of speech, there had been a lot more dicta on that particular subject, but he did not. Nor did he argue that the warning he got from the security was not sufficient as a trespass warning. Maybe it was at the time, but today a trespass warning is done in writing, and then you can be arrested for trespassing if you violate that written warning. So there's an extra added layer of criminality or notice if you're trespassed from a property. So in that case, the court upheld the previous court, the lower court, and said that there was nothing wrong, there's no error in that conviction, which is important because that did also conflict with freedom of speech in some degree, other than Korn didn't bring it up. But let's look, those are the only two court cases in Florida, so there's just not any precedent that relates to the Pruneyard decision in California. But let's look at the AG's decisions. So the Florida Attorney General has made a decision in this area as well. So we'll call it the International Society of Krishna Consciousness, or ISKCON, wanted to have a booth at the Volusia County Fair. Volusia County Fair does not allow any solicitation or commercial booths selling things. So they said no because they believed, since Krishna oftentimes solicits for donations after giving someone a religious book, they will solicit for donations. Now, those donations are voluntary. If you just want their books and you don't want to give a donation, that's not a problem with Krishna. But they do ask for a donation when they've given you a book. I know because I've donated to Krishna and received their books, and very nice people. They were not aggressively asking for donations. They just very nicely and passively asked me if I'd like to donate to their cause, and I did. So, in this case, the Volusia County Fairgrounds said, no, you can't do that because we expect that you will use this booth for commercial activities. So, ISKCON then went to the Attorney General, who concurred with ISKCON and said that because the fairgrounds are state-owned, tax-paid for, they have an added level of freedom of speech that protections that private businesses may not have or enjoy. The private businesses would have, that they would not have the same abilities to stop freedom of speech, being that it's a state fair and on the fairgrounds. So in that case, the Attorney General agreed with ISKCON. So there's also the Second District Court of Appeals, which is the Florida Court of Appeals. They had a chance to differentiate between the federal constitution and state constitution. They chose not to. They're looking for the Supreme Court of Florida to actually make that differentiation if someone's going to. So then there was also the Florida Canners Association versus the state. And this was a rule that required that there be the state origin on grapefruit products, saying that you have to say where the grapefruits came from on these products. And the court said that federal and state constitutions are interchangeable, and they will not be treated differently. So this court actually said that the state of Florida's constitution and federal constitution are used interchangeably, and there was no difference. But this doesn't mean that's true, because Florida's constitution is written with the word restrain, and is very much similar to California's constitution, which was used very successfully in the Pruneyard decision. So right now, while there's not any precedents, we can expect there will be cases setting precedents, possibly even ours. In other states, there has been trends lately. More and more courts have chosen to lean toward their state constitutions and their sovereignty of using that instead of interpreting only from the federal constitution. Such as, and they're using the adequate state grounds doctrine. So California also had Wilson versus Superior Court of LA County. In Oregon Supreme Court, they had DeRoss, or DERAS, versus Myers. And then in Virginia, they had Robert versus the City of Norfolk. All three cases dealt with using the state constitution as the way to interpret their ways of dealing with freedoms, like freedom of speech or amendments and rights. So if you look at the Miami Law Review's complete analysis and journal of how the Pruneyard versus Robbins deals and it would affect Florida, they did a comprehensive review on it. And I'll quote this from the review because I found this at the very end of the review, and I found this to be very telling on what we'll see in future cases. It says, quote, "As in California, malls increasingly are becoming a way of life in Florida. Prohibition from exercising even limited constitutional freedom therein would substantially deny such freedoms. So that is why we are out here trying to create a town hall, is because now there's just no real way other than the internet, which we don't know who we're talking to on the internet. And they might not be our neighbors. They could be not even from this country. There's just no way of telling who you're just talking to when you're having political discussions on the internet. You might be talking to a Russian troll. You just never know. So the bottom line is that we're trying to create, hi everybody, I have the dump truck bus, I'm always getting honks and things, a place for us to talk about town hall issues and to discuss politics again in America and to bring us back together. We are divided states of America, and we need to find ourselves to be more united. I believe the first rule of therapy is to get things on the table and discuss them, and that's what we're trying to set up here. And these are the decisions in America that have given us the right to do this on private property, as long as we're not causing disturbance to the business. We're not preventing the business from having customers. We're not hostile, running their customers off. We're not doing anything that would be damaging to the business at all. And when businesses are utilizing trespassing laws, private property rights, to prevent normal talking of politics and dissenting opinions from incumbent president or any other thing thereof, it is a disservice to the American public, to citizens who strive so hard to live in a land of democratic values. And so that is what this is all about. I really appreciate your time in listening to this and maybe understanding more about how freedom of speech works on private property and why this is so important today. My name is Pastor Andrew Stevens. I'm with the Church of Common Good here in Florida. I'm working on the American Culture TV project. I hope to see you soon in a dump Trump bus at a shopping area near you. Love and light. Have a good day.